Good day everyone, here are some of the possible questions that might come up during the bar examinations. In the subject of political law. Again, disclaimer, this did not come from any other source. It came from our own insight and opinion, and again, take it with a grain of salt. Okay, let's proceed. Petitioners questioned the validity of the K-12 law, claiming that the enrolled bill which the President signed into law varies significantly from the reconciled version of the bill as approved by Congress and reported in the Senate Journal on January 30, 2013. They raised the ruling in Astorga versus Villegas that the court should look into the entries in the journal to determine whether the K-12 law was duly enacted. Should the court apply the ruling in Astorga and look into the entries in the journal to determine whether the law was duly enacted? No, the court did not look into the entries in the journal to determine whether the law was duly enacted because the enrolled bill doctrine applies in this case. Under the enrolled bill doctrine, the signing of a bill by the Speaker of the House and the Senate President and the certification of the Secretaries of both Houses of Congress that it was passed is conclusive not only as to its provisions but also as to its due enactment. The petitioner's application of the Astorga case is misplaced because there is no enrolled bill to consider in the aforesaid case. As such, the court is constrained to consult the entries in the journal to determine whether the text of the bill signed by the Chief Executive was the same text passed by both houses of Congress. This case presents no exceptional circumstance to justify the departure from the salutary rule. From the case of Cotescup versus Secretary of Education. In 2012, DepEd started unclogging the BEC to conform to the K-12 curriculum. Thus, Department Order No. 31 was issued setting forth policy guidelines in the implementation of grades 1 to 10 of the K-12 curriculum. Department Order No. 31 provides that effective school year 2012 to 2013, the new K-12 BEC, which follows a spiral approach across subjects and uses the mother tongue as a medium of instruction from grade 1 to 3 shall be implemented in grades 1 and 7 of all public elementary and secondary schools, and while private schools are enjoined to do the same, they may further enhance the curriculum to suit their school's vision and mission. A petition was filed claiming that Department Order No. 31 is a usurpation of the legislative authority as it creates a law without delegation of power. According to the petitioners, Department Order No. 31, which changed the curriculum and added 2 more years to basic education, has no statutory basis. It also violates the constitutional right of parents to participate in planning programs that affect them and the right to inform on matters of public concern. Rule on the petition. The petition is without merit because petitioner's argument lacked factual and legal basis. Department Order No. 31 did not add 2 years to basic education, nor did it impose additional obligations to parents and children. Department Order No. 31 is an administrative regulation addressed to DepEd personnel, providing for general guidelines on the implementation of a new curriculum for grades 1 to 10 in preparation for the K-12 basic education. Department Order No. 31 was issued in accordance with the DepEd's mandate to establish and maintain a complete, adequate, and integrated system of education, relevant to the goals of national development, formulate, plan, implement, and coordinate, and ensure access to, promote equity in, and improve the quality of basic education, and pursuant to the Secretary's authority to formulate and promulgate national educational policies under existing laws. Based on the case of Cotescup versus Secretary of Education. A law was enacted making kindergarten and senior high school compulsory. For petitioners, compulsory kindergarten and senior high school expanded the constitutional definition of elementary education, and that the Congress violated the rule of constitutional supremacy when it made kindergarten and senior high school compulsory. On the other hand, the OSG contends that while Section 2, Article 14 states that elementary education shall be compulsory, it did not preclude Congress from making kindergarten and secondary education mandatory. Is the law constitutional? Yes, the law making kindergarten and senior high school compulsory is constitutional. The Supreme Court also maintains that while Section 2, Article 14 states that elementary education shall be compulsory, it did not preclude Congress from making kindergarten and secondary education mandatory. The Constitution did not curtail the legislature's power to determine the extent of basic education. It only provided a minimum standard, that elementary education be compulsory. By no means did the Constitution foreclose the possibility that legislature provide beyond the minimum set by the Constitution, based on the case of Cotoscope versus Secretary of Education. How do you determine whether or not a statute constitutes undue delegation of power? The court has adopted two tests: the completeness test and the sufficient standard test. Under the first test, the law must be complete in all its terms and conditions when it leaves the legislature, such that when it reaches the delegate, the only thing he will have to do is to enforce it. The sufficient standard test, on the other hand, mandates adequate guidelines or limitations in the law to determine the boundaries of the delegate's authority and prevent the delegation from running riot. To be sufficient, the standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. Based on the case of Cotoscope versus Secretary of Education. At 2 a.m. of August 17, 2010, SPO1 PARDS was conducting monitoring and possible arrest of violators of RA 9165 at Porok 3, Barangay Poblacion, Muntinlupa City. He saw DOMs standing around the area. SPO1 PARDS grabbed the hands of DOMs and seized therefrom one heat-sealed transparent plastic sachet containing the substance suspected to be shabu. DOMS was charged with illegal possession of dangerous drugs and claimed that the integrity of the shabu seized has been duly preserved. May DOMS be convicted of illegal possession of dangerous drugs? No, DOMS may not be convicted of illegal possession of dangerous drugs because the search and seizure was not valid. DOM's acts of standing on the street and holding a plastic sachet in his hands are not by themselves sufficient to incite suspicion of criminal activity or to create probable cause enough to justify a warrantless arrest. Section 3, Paragraph 2 of Article 3 of the 1987 Constitution provides that evidence obtained and confiscated on the occasion of such unreasonable searches and seizures are deemed tainted and should be excluded from being the proverbial fruit of a poisonous tree. In other words, evidence obtained from unreasonable searches and seizures shall be inadmissible in evidence for any purpose in any proceeding. Based on the 2019 case of Marlon Dominguez versus People of the Philippines. An information was filed against Dick for violating Section 5, Article 2 of RA 9165. Dick pleaded not guilty to the charge. On April 10, 2015, he filed a petition for bail. The RTC grants Dick's application for bail. May the court grant the application for bail? Yes, the court may grant Dick's application for bail when the evidence of guilt is not strong. Section 13, Article 3 of the Constitution states that all persons, except those charged with offenses punishable by reclusion perpetua when the evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties or be released on recognizance, as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. From the case of People of the Philippines versus Novotanes. When are searches and seizures considered unreasonable? Section 2, Article 3 of the 1987 Constitution mandates that a search and seizure must be carried out through or on the strength of a judicial warrant, predicated upon the existence of probable cause, absent which such search and seizure becomes unreasonable within the meaning of said constitutional provision, based on the case of People of the Philippines versus Marlon Cristobal. Petitioner John Michael Langan prays for his release from prison on the ground that he has been deprived of his rights to due process and to competent counsel. Regional Trial Court found accused John Michael guilty beyond reasonable doubt on the crime of violation of Section 11, Article 2 of Republic Act 9165. He then filed a petition for the issuance of the writ of habeas corpus under Rule 102 of the Rules of Court, should the petition be given due course. No, the petition for a writ of habeas corpus should not be given due course because the petitioner's confinement and detention is based on some legal process. Jurisprudence states that if a person's liberty is restrained by some legal process, the writ of habeas corpus is unavailing. The writ cannot be used to directly assail a judgment rendered by a competent court or tribunal which, having duly acquired jurisdiction, was not ousted of its jurisdiction through some irregularity in the course of the proceedings. Based on the case of INRE, the writ of habeas corpus of Michael Labrador Abellana versus Honorable Mirando P. Paredes. NGCP is a private corporation engaged in the business of transmitting electric power from generating plants of power producers to distributors. It obtained a franchise under Republic Act 9511. To construct and maintain the Mariveles-Limay transmission line project, it sought to expropriate upon payment of just compensation a certain area of a parcel of land situated in Mariveles, Bataan. The subject property is part of the Petrochemical Industrial Park, which is under the management of PAFC. NGCP sought to expropriate the subject property from petitioner PAFC. According to respondent NGCP, it sought to exercise its right of eminent domain over the subject property because negotiations conducted between the petitioner PAFC and respondent NGCP on the establishment of transmission lines on the subject property were unsuccessful. Respondent NGCP invoked its general authority to exercise the right of eminent domain under Section 4 of RA number 9511. In its answer, PAFC maintained that NGCP cannot expropriate the property because the land sought to be appropriated is already devoted to a public purpose. Should NGCP's expropriation case be given due course given that the property is already devoted for a public purpose? Yes, the expropriation case filed by NGCP should be given due course because the property in question is a patrimonial property. Even if patrimonial property refers to land owned by the state or any of its instrumentalities, such is still deemed private property as it is property held by the state in its private and proprietary capacity, and not in its public capacity, in order to attain economic ends. Hence, NGCP has the authority under Republic Act number 9511 to expropriate the subject property. Based on the case of PAFC versus NGCP, Ate V won the elections and took her oath. Sheriff Pai filed a quo warranto petition before the HRET averring that Ate V was ineligible to sit as a member of the House, as she remained to be an American citizen, not having complied with the requirements of RA 9225 for reacquisition of Philippine citizenship. During the pendency of the case, Ate V completed her term and was even re-elected in the subsequent elections. Ate V sought the dismissal of the case for being moot and academic. Rule on Ate V's contention. The petition of Ate V for the dismissal of the case for being moot and academic should be denied because her citizenship still presents a justiciable controversy. Jurisprudence states that the resolution of the case remains relevant as the continued tenure as a member of the House hinges on the resolution of the issue of whether she had validly reacquired her Philippine citizenship. Stated differently, should the court find that she is ineligible for not being a Philippine citizen, she must be removed from office. Needless to say, the issue of her citizenship remains to be a justiciable controversy. Hence, the case is not rendered moot and academic. Based on the case of Philip Hernandez Picho versus HRET. Petitioner Bal is a member of the Seventh-day Adventist Church whose fundamental beliefs include the strict observance of the Sabbath as a sacred day. Bal enrolled at the MSU Colleges of Medicine as a first-year student. To avoid conflict between his academic and church worship on Saturday, Bal wrote to Achi requesting that he be excused from attending his classes in the event that a regular weekly session is rescheduled to a Saturday, and expressed his willingness to make up for any missed activity or session due to his absence. Some of Bal's classes and examinations were moved from weekdays to Saturdays. In one instance, Bal was unable to take his histopathology examination on a Saturday. Despite his request for exemption, no accommodation was given. As a result, he received a failing grade of 5 for that particular module and was considered ineligible to retake the exam. Several pastors and officers of the Seventh-day Adventist Church sent a letter to respondent requesting for possible audience with the MSU School Board. Balagan wrote a letter to Achi to seek reconsideration regarding the situation, and yet his request fell on deaf ears. Was the petitioner's constitutional right to freedom of religion violated by the respondents? Yes, the petitioner's constitutional right for freedom of religion was violated because the Bill of Rights guarantees citizens the freedom to act on their individual beliefs and proscribes government intervention unless necessary to protect its citizens from injury or when public safety, peace, comfort, or convenience requires it. Here, the respondent's concerted refusal to accommodate petitioner Bal rests mainly on extra-legal grounds which cannot, by no stretch of legal verbiage, defeat the latter's constitutionally enshrined rights. That petitioner Bal is being made by respondents to choose between honoring his religious obligations and finishing his education is a patent infringement of his religious freedoms. As the final bulwark of fundamental rights, this court will not allow such violation to perpetuate any further. Based on the case of Valmores versus Achacoso. In construction of tax laws, public purpose is always presumed, true or false? True. This is in consonance with the doctrine that, like any other statute, tax legislations carries a presumption of constitutionality. What is the general rule on construction of tax exemptions? Tax exemptions and exclusions are regarded as derogation of sovereign authority and to be construed strasimi juris against the person or entity claiming the exemption. What are the exceptions to the strict construction of tax exemptions? First, when the statute granting exemptions provides for liberal construction thereof. Second, in case of special taxes relating to special cases and affecting only special classes of persons. Third, if exemptions refer to public property. Fourth, in cases of exemptions granted to traditional persons who are exempt, such as religious, charitable, and educational institutions. Fifth, in cases of exemptions in favor of the government, its political subdivisions or instrumentalities. Sixth, if the taxpayer falls within the purview of exemption by clear legislative intent. In tax rulings, what is the principle of non-retroactivity? Under the principle of non-retroactivity of tax rulings, any revocation, modification, or reversal of any of the rules and regulations or any of the rulings or circulars promulgated by the Commissioner shall not be given retroactive application if the revocation, modification, or reversal will be prejudicial to the taxpayers. Section 246 of the NRIC. In tax rulings, what are the exceptions to the principle of non-retroactivity? Where the taxpayer deliberately misstates or omits material facts from his return or any document required of him by the BIR. Second, where the facts subsequently gathered by the BIR are materially different from the facts on which the ruling is based. Last, when the taxpayer acted in bad faith. Section 246 NIRC. What is the doctrine of imprescriptibility of taxes? Unless expressly provided by law, the statutes of limitation do not run against the state. Again, unless expressly provided by law, the statutes of limitation do not run against the state. What is double taxation? Double taxation is defined as taxing the same person twice by the same jurisdiction for the same thing. Is double taxation unconstitutional? No, there is no constitutional prohibition against double taxation in the Philippines. It is something not favored, but it is permissible, provided some other constitutional requirement is not violated, such as the requirement that taxes must be uniform. Relinquishment of the power of taxation may be presumed. True or false? False. The power of taxation is a high prerogative of sovereignty. The relinquishment is never presumed. What is the doctrine of equitable recoupment? A tax presently assessed against a taxpayer may be recouped or set off against a tax illegally or erroneously collected or overpaid. Is the doctrine of equitable recoupment applicable in the Philippines? No, this is a common law principle and is not binding in our courts, and there is nothing in our laws authorizing its acceptance and application, because if it will be allowed, both the collecting agency and the taxpayer might be tempted to delay and neglect the pursuit of their respective claims within the period prescribed by law. What is the general rule on the compensation or set-off of taxes? The general rule is that no set-off is admissible against the demands for taxes levied for general or local government purposes, since tax liability is a legal, not a contractual obligation. Taxes cannot be subject to compensation because the government and the taxpayers are not creditors and debtors of each other. When may taxes be subject to offsetting? As exception to the general rule, taxes may be subject to compensation or set-off when the determination of the taxpayer's liability is intertwined with the resolution of the claim for tax refund or erroneously or illegally collected taxes under Section 299 of the NIRC, where both claims of the government and taxpayers against each other have already become due, demandable, and fully liquidated.